So here's the thing, Mr. Boudwin, I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time. So again, you are Jarrett Matthews, and Mr. Matthews, get back to my, get back where I need to be here, hold on. It's cause number 23, DCCR 1211, and Mr. Matthews is charged with unlawful possession of a firearm by a felon from September 13th of 2022. Mr. Kimler has filed a motion asking that I reduce his bond, and bond is currently set at $30,000. It looks like, is that correct?
Is that right?
Mr. Kimler?
I think it was more than, it's 100 is what I thought.
So it was initially set at 30. So let me see here. $100. Okay. So I wonder why.
We'll take 30, Your Honor.
Sure you will. I'm just looking at, okay, so apparently back in September of 2022, there was a bond set, and then yes, Mr. Matthews made that bond.
Then he went to custody in Louisiana and stayed in custody.
And when he got back, it was reevaluated in a bond set at $100,000.
Right.
So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration documentation that was used at the jail, and also the public safety report. Mr. Kimler, you may proceed.
Your Honor, I suppose the initial bond was $30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the court when you're on. He can explain his current.
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stay in Lake Charles with my mom. From when I bonded out here the first time, I never missed court. I never failed a drug test or anything.
But you were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This is my most previous charge.
Most recent.
Most recent charge.
And what was that charge?
It was a convicted felon firearm charge.
Jefferson Davis Parish, right?
Yes, ma'am.
And what was your sentence?
4 years. I was in the military 7 years. I kind of have a little PTSD. I was going to dental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor. He's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that if we come back on a contested sentence, that he could do the probation. Is that what you believe?
Yes, sir.
Did we have a hold on him when he was in?
It was my understanding, Judge, and the reason for the offer being obviously you see the offense date is quite
Right.
old. He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right,
Well, for
so,
Veterans Court, right? But I
Right.
think we could transfer the probation.
well, I guess, if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that, even if we didn't have a hold, I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment,
Right.
but the time of this indictment and now,
We put a hold on, 3/19/24.
okay, so obviously would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes have reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which,
He's asking.
he would have enough time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that.
I've explained.
Opportunity.
He wants an opportunity to do probation, so.
Well, that's between y'all then. And so
Well, it could be
then,
a-
all right, back to the bond.
Could be a
So,
gap, all right.
look at one more thing real quick. So here's the thing. He's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here. So at this time, based on all of the information that I've received, again, from that public safety report, as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll try to maybe figure something out.
All right, thanks.
We're talking about that.
All right, so you're Stephen Boudwin?
Yes, ma'am.
And let me get this pulled up. Is it,
And so if I can,
hold on just a
Okay.
second. Let me just get what I need to, and then I'll let y'all. Oh, this is, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to your honor
Yes.
about on Friday. She bonded him out.
she actually, I wasn't sure about this. When he called me yesterday and about a bond hearing. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case and we were waiting on a PSI. And we were looking at, we're going to see what happened with parole. I think he's been released from parole. The parole hold's been lifted.
No response.
And then I get a call from her, and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was
I
forwarded
have it.
to me. And I told him that he needed to go and contact the probation department to do a PSI. I mean, I just told him yesterday. I don't know if he's contacted him yet or not.
Yes, they scheduled me to come in today, so I'm coming off the court.
Ms. Maltino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend, and I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time your honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday before I talked to you, Judge, and they were going to lift the hold. So that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously. And so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Boudwin, I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she wouldn't bonded you out. She's written me a letter. At this point, I don't care about any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person. That's through your phone. That's through sending messages. Again, she cannot say, it's okay, I won't tell. If something happens and she changes her mind again, which is likely, it sounds like, and contacts Ms. Malfino and says, okay, I thought it was okay, but now it's not, he's coming around, you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. You have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay. Okay.
All right, okay, you're free to go.
Thank you, Judge. I just felt it important to document.
I totally agree. Thank you, Ms. Malfino.